The gavel crashes down in courtroom 3A of the Federal District Court, its echo bouncing off marble walls that have witnessed decades of justice and injustice alike. Behind the elevated mahogany bench sits Judge Victoria Thornfield, a woman whose silver hair is pulled into a severe bun and whose pale blue eyes survey her domain with the cold satisfaction of absolute power. She adjusts her black robes with the practiced arrogance of someone who has never faced consequences for her actions. Another one of these frivolous civil rights claims. Do you people even understand what discrimination actually means? Or do you just throw around legal terms hoping something will stick? The words hang in the air like poison gas, directed at the lone black woman standing at the defendant's table. The woman appears unremarkable at first glance. Medium height, wearing a simple navy blazer and modest jewelry, her hair pulled back in a professional style that suggests respect for the institution. But there's something unsettling about her stillness, the way her dark eyes never waver from the judge's face, as if she's cataloging every word for some future purpose. Your Honor, I understand the legal definition of discrimination under both Title VII and Section 1983 quite clearly. The woman's voice carries no tremor, no deference that Judge Thornfield expects from defendants in her courtroom. In the gallery, court watchers shift uncomfortably, sensing an undercurrent they cannot name. The bailiff, a mountain of a man named Camden Pierce, straightens slightly, his hand moving instinctively toward his weapon. Ms. Sterling, is it? Let me make something crystal clear. In my courtroom, pro se litigants don't lecture me on constitutional law. What Judge Thornfield doesn't know is that the woman she's addressing with such contempt holds credentials that would make her blood run cold. The briefcase beside Harper Sterling contains documents that will shatter not just this judge's career, but her entire worldview. The clock above the courtroom door reads 10:17 a.m. In exactly 93 minutes, Federal Judge Victoria Thornfield will discover that she has just insulted the most dangerous law enforcement official in the building. But for now, she continues her performance. Unaware that every word is being recorded by equipment sophisticated enough to distinguish a whisper from 50 feet away. Federal District Court Southern District operates with the mechanical precision of institutional routine. By 9:30 a.m., the hallways buzz with the controlled chaos of American justice. Defense attorneys wheeling briefcases, prosecutors clutching coffee cups like lifelines, and citizens summoned to serve democracy's machinery. Among them moves Harper Sterling, unremarkable in her navy suit, carrying herself with the quiet confidence of someone accustomed to navigating complex systems. The morning air carries the scent of fresh coffee and nervous perspiration as Harper approaches the courthouse steps. She pauses for a moment, her fingers adjusting the strap of her leather briefcase with movements too precise for casual gestures. Inside that case lie documents that could topple careers, destroy reputations, and send respected officials to federal prison. But nobody watching her ascent would suspect that the woman in the conservative business attire represents the federal government's most sophisticated civil rights enforcement unit. At the courthouse entrance, metal detector alarms pierce the morning air. The security guards wave through white attorneys with familiar nods, but Harper faces additional scrutiny. Court Officer Gage Morton, a thick-necked man whose uniform strains against his gut, examines her briefcase with exaggerated thoroughness. Ma'am, you're gonna need to remove everything. Laptop, files, pens, everything. Harper complies without comment, her movements precise and economical. She doesn't protest when Morton holds up each document, doesn't react when he questions the purpose of her legal research files. Her silence is professional, practiced, and somehow more unsettling than any complaint would be. As Morton rifles through her carefully organized papers, Harper's eyes track the security cameras positioned throughout the entrance hall, noting blind spots and recording angles with the automatic assessment of someone trained in surveillance procedures. What's all this legal stuff for? You a lawyer or something? The question hangs in the air as Morton waves a thick folder of case law precedents. Harper's response comes measured and calm. I'm representing myself in a civil rights matter. I believe in being prepared. Morton snorts, a sound that suggests he's heard this line before from desperate defendants hoping to sound more competent than they appear. He hands back her materials with barely concealed disdain, unaware that the woman before him has prosecuted federal cases that sent judges, politicians, and law enforcement officials to prison for civil rights violations. What you just witnessed is only the beginning of the most shocking courtroom takedown in federal history. This story gets more unbelievable by the minute. So make sure you're subscribed and hit that notification bell because you won't want to miss what happens when this judge realizes who she's really dealing with. In the elevator ascending to the third floor, Harper stands beside two white attorneys discussing their cases with casual confidence. They speak loudly, certain of their welcome in these halls. The younger attorney, fresh from law school with his diploma still warm, complains about pro se litigants clogging the federal courts with frivolous lawsuits. These people think watching legal dramas qualifies them to practice constitutional law. Judge Thornfield usually disposes of them in under 10 minutes. His colleague, a seasoned defense attorney with silver temples and expensive shoes, nods knowingly. Thornfield's efficient with the self-represented crowd, especially the civil rights cases. She has zero patience for what she calls discrimination theater. Harper listens without appearing to listen, her dark eyes focused on the ascending floor numbers while her mind catalogs every detail of their conversation. These men speak with the casual cruelty of people insulated from consequence, unaware that their words are being absorbed by someone with the power to investigate every case they've mentioned. The elevator dings softly as it reaches the 3rd floor, and Harper steps out behind the 2 attorneys. They head toward the attorney conference room while she turns left toward the public seating area outside courtroom 3A. The hallway here bustles with the morning's legal business. Clerks carrying files, lawyers huddled in whispered conferences, and citizens clutching subpoenas and summons like lifelines. Courtroom 3A hosts civil rights litigation, where federal civil rights violations face judicial scrutiny. The gallery fills with plaintiffs' families, civil rights advocates, and legal observers. These are people seeking justice for police brutality, workplace discrimination, and voting rights violations. Harper takes a seat in the back row, her presence generating no particular attention among the diverse crowd seeking federal protection for constitutional violations. She opens her briefcase and removes a yellow legal pad, already filled with neat handwriting that documents months of preparation. To any observer, she appears to be reviewing her case notes like countless other pro se litigants. But the notes contain information that would terrify the court staff if they could read them. Documented patterns of judicial bias, statistical analysis of case outcomes, and detailed profiles of every person who will play a role in today's proceedings. Judge Thornfield emerges from her chambers with the bearing of institutional authority. At 62, she has presided over this courtroom for 15 years, building a reputation for harsh treatment of civil rights plaintiffs and defendants who represent themselves without attorneys. Court watchers recognize her pattern: lengthy proceedings for cases with minority plaintiffs, swift dismissals when evidence challenges law enforcement conduct. The judge's morning ritual never varies. She reviews her docket with court clerk Lila Fairbanks, receives coffee prepared exactly to her specifications, and spends precisely 5 minutes reading newspaper headlines on her tablet. This routine reflects a woman who believes in order, hierarchy, and the absolute authority of her position. What it doesn't reflect is someone prepared for the systematic challenge that's about to unfold. Fairbanks, a woman in her 40s with prematurely gray hair and the harried expression of someone perpetually behind schedule, approaches the bench with today's files. Her coordination with Judge Thornfield extends beyond normal clerk duties into territory that would concern judicial oversight authorities if they knew the full extent of their collaboration. Your Honor, we have 17 cases on today's docket. The Sterling matter should be straightforward. Another pro se employment discrimination case without merit. The casual dismissal of Harper's case before any evidence has been presented reveals the predetermined nature of these proceedings. Fairbanks speaks with the confidence of someone who knows exactly how this morning will unfold, unaware that her words are being absorbed by federal investigators who have been building a pattern of practice case for 18 months. The morning's first case demonstrates Thornfield's judicial temperament with brutal clarity. A Hispanic man seeking damages for excessive force faces immediate skepticism from the bench. His attorney, a public defender carrying a caseload that would crush most lawyers, struggles to present evidence while Thornfield interrupts with procedural objections that have no basis in federal court rules. Counselor, I find your client's testimony lacks credibility. Police officers don't simply assault citizens without provocation. The statement reveals bias so profound it would constitute grounds for automatic reversal on appeal. Thornfield has predetermined the outcome based on the plaintiff's race and the defendant's profession, violating every principle of judicial neutrality. Yet she speaks with the absolute confidence of someone who has never faced consequences for such statements. When the Hispanic man's English falters under pressure, Thornfield sighs audibly, making no effort to provide translation assistance required under federal court rules. The sigh carries volumes of disdain, suggesting that language barriers constitute evidence of dishonesty rather than communication challenges that federal courts encounter daily. Speaking of legal protection, have you ever worried about your rights being violated in court? Legal Shield offers 24/7 access to experienced attorneys for less than $25 per month, Whether it's traffic violations, workplace discrimination, or any legal concern, you'll have professional representation ready. Don't wait until you're facing a biased system alone. Visit LegalShield.com and get your first consultation free, because everyone deserves equal protection under the law, regardless of who's on the bench. Defense counsel objects to basic evidence with motions that federal appellate courts have repeatedly rejected, but Thornfield sustains every objection with rulings that demonstrate either profound ignorance of federal civil rights law or willful disregard for constitutional protections. Her coordination with defense attorneys becomes increasingly obvious as the morning progresses. This is no traffic court or municipal venue. Federal district court handles violations of constitutional rights, civil rights statutes, and federal criminal law. The jurisdiction extends across 7 counties, giving Thornfield's decisions impact over millions of citizens. Her power to interpret federal civil rights law affects employment discrimination, police misconduct, and voting rights across the region. The weight of this authority should humble any federal judge, but Thornfield wields it with the casual cruelty of someone who believes certain people deserve protection while others deserve punishment. Her worldview divides citizens into those worthy of constitutional rights and those who must prove their worthiness through deference and submission. Harper observes this performance with the clinical detachment of a federal investigator documenting evidence for prosecution. Every biased ruling, every procedural violation, every constitutional infringement gets recorded in her memory with the precision of someone trained to build federal cases that will survive a polite scrutiny and congressional oversight. When Thornfield's clerk calls Sterling versus Federal Bureau of Prisons, Harper rises and approaches the plaintiff's table with movements that suggest familiarity with courtroom procedures. She doesn't hesitate at the bar, doesn't look around for guidance, doesn't display the nervousness typical of pro se litigants facing federal judges for the first time. Judge Thornfield glances at Harper's pro se status notation and immediately adopts the tone reserved for unrepresented litigants she considers beneath serious consideration. Her voice drops to the patronizing register typically reserved for children or pets. Ms. Sterling, I see you're representing yourself. Are you certain you understand the complexities of Section 1983 litigation? The question drips with condescension, suggesting someone of Harper's appearance couldn't possibly comprehend federal civil rights law. Every word reinforces assumptions about race, education, and legal competence that would horrify civil rights advocates if they understood the systematic nature of Thornfield's bias. Harper's response reveals nothing beyond respectful acknowledgement of the court's authority. Yes, Your Honor, I'm familiar with the relevant statutory framework. The answer contains exactly the level of legal sophistication appropriate for someone who has spent months preparing a federal civil rights case. No more, no less. Harper provides no hint of the encyclopedic knowledge of constitutional law that 15 years of federal enforcement has burned into her memory. Thornfield begins her assault on standard civil rights procedures with the mechanical precision of someone who has refined these tactics over years of practice. She demands Harper explain legal concepts typically assumed in federal court, questions her understanding of federal jurisdiction, and requires detailed recitation of constitutional amendments. Each demand treats Harper as presumptively incompetent rather than exercising normal judicial discretion. The pattern reveals systematic harassment designed to frustrate civil rights plaintiffs into abandoning their cases rather than facing continued humiliation. Before we proceed, Ms. Sterling, I need you to demonstrate understanding of qualified immunity doctrine, the Monell standard for municipal liability, and the deliberate indifference standard under Eighth Amendment jurisprudence. This is judicial hazing elevated to an art form. No pro se litigant should be expected to recite complex constitutional doctrine from memory, yet Thornfield delivers this demand with the casual authority of someone requesting the time of day. Her expectation of failure radiates from the bench like heat from asphalt. Harper pauses for exactly 3 seconds, long enough to suggest careful consideration without revealing instant familiarity with concepts that represent her daily professional vocabulary. When she responds, her words carry precisely the level of competence expected from someone who has done extensive research without professional legal training. Your Honor, qualified immunity shields government officials from civil liability unless they violated clearly established statutory or constitutional rights that a reasonable person would have known. Monell requires proof of municipal policy or custom causing the constitutional violation. Deliberate indifference requires actual knowledge of substantial risk and disregard of that risk. The response demonstrates legal knowledge that should raise eyebrows throughout the courtroom. Harper has recited complex constitutional doctrine with precision that rivals practicing civil rights attorneys, yet she maintains the demeanor of someone drawing upon research rather than professional experience. Judge Thornfield's expression shifts almost imperceptibly, revealing the first crack in her assumption of Harper's incompetence. The answer exceeds her expectations for pro se legal knowledge, creating cognitive dissonance between her racial assumptions and the evidence before her. Defense attorney Wells Ashford represents the Federal Bureau of Prisons in this employment discrimination case with the casual confidence of someone accustomed to favorable treatment from the bench. His coordination with Judge Thornfield becomes immediately apparent as he receives evidentiary rulings and procedural latitude that Harper faces constant challenges to obtain. Your Honor, I object to plaintiff's characterization of federal employment policy. Her pro se status doesn't entitle her to ignore basic evidentiary standards. The objection reveals the coordinated strategy underlying these proceedings. Ashford challenges Harper's legal arguments not on their merit but on her status as a self-represented litigant, suggesting that constitutional analysis becomes invalid when presented by someone without a law degree. Thornfield sustains the objection with enthusiasm that borders on relief. Harper's competent legal analysis threatens the predetermined narrative of pro se incompetence that justifies dismissing civil rights cases without serious consideration. Sustained. Ms. Sterling, please confine your arguments to simple statements of fact rather than legal conclusions. The ruling violates basic principles of federal civil procedure, which permit all litigants to present legal arguments regardless of representation status. Thornfield's attempt to limit Harper to factual statements effectively eliminates her ability to present a civil rights case that necessarily involves complex constitutional analysis. Harper documents this procedural violation with the same clinical precision she applies to every aspect of these proceedings. Her legal pad fills with notes that appear routine but actually constitute a comprehensive record of judicial misconduct suitable for federal prosecution and appellate reversal. Your Honor, federal civil rights litigation necessarily involves legal analysis of constitutional violations. May I respectfully request clarification of the court's evidentiary requirements? The question demonstrates legal sophistication that should alert everyone in the courtroom to Harper's unusual preparation. She challenges the judge's ruling using language that suggests familiarity with federal appellate standards while maintaining the deferential tone appropriate for pro se litigants. Thornfield's response reveals growing irritation with Harper's refusal to accept dismissive treatment without challenge. Most pro se civil rights plaintiffs either capitulate to judicial pressure or react emotionally to procedural harassment. Harper's persistent professionalism disrupts the normal dynamics that allow systematic bias to operate without scrutiny. Ms. Sterling, this court's evidentiary requirements are clearly established in federal rules that you should have researched before filing your complaint. Your continued questions suggest inadequate preparation for federal litigation. The criticism attempts to shift blame for procedural violations onto Harper rather than acknowledging that Thornfield's rulings contradict established federal court practice. This deflection technique allows biased judges to maintain the appearance of legal propriety while systematically denying constitutional protections to disfavored litigants. Harper accepts the criticism without protest, maintaining the respectful demeanor expected from someone facing the awesome authority of federal judicial power. Her composure under attack demonstrates either exceptional self-control or professional familiarity with hostile legal environment that most pro se litigants would find overwhelming. The injustice you're seeing is heartbreaking, but what's about to unfold will restore your faith in the system. If stories like this move you, smash that like button and share this with someone who needs to see that justice can still prevail against corruption. Thornfield attempts to exclude Harper's evidence using standards that don't apply to civil rights cases, demonstrating either profound ignorance of federal civil rights law or willful manipulation of legal procedures to achieve predetermined outcomes. She cites criminal procedure rules for civil proceedings, misapplies federal evidence standards, and suggests burden of proof requirements that contradict established federal precedent. Ms. Sterling, your documentary evidence lacks proper authentication under Federal Rule of Evidence 901. I'm excluding these materials unless you can establish chain of custody through competent testimony. The ruling applies criminal evidence standards to civil proceedings where authentication requirements are significantly less stringent. Thornfield's demand for chain of custody testimony effectively prevents Harper from presenting evidence that federal courts routinely accept in civil rights cases. A competent civil rights attorney would object immediately to this obvious procedural error, but Harper simply observes, taking notes with unusual precision that suggests familiarity with appellate procedures rather than resignation to unfair treatment. Her documentation appears routine but actually creates the comprehensive record necessary for federal appeals and judicial misconduct complaints. Court Clerk Lila Fairbanks demonstrates subtle sabotage that reveals the institutional nature of bias against civil rights plaintiffs. She provides Harper incorrect filing information, misfiles her documents, and loses evidence submissions with timing that suggests coordination rather than coincidental error. Ms. Sterling, I'm afraid your motion for summary judgment was never received by the court. You'll need to refile with proper service on all parties. The claim contradicts Harper's careful documentation of every filing, which includes certified mail receipts and electronic confirmation of court receipt. Fairbanks's assertion of non-receipt constitutes either systematic incompetence or deliberate sabotage, designed to frustrate Harper's case through procedural manipulation. Harper documents each irregularity without protest, her silent cataloging more ominous than any objection would be. Most pro se litigants would react emotionally to obvious procedural sabotage, but Harper's clinical documentation suggests professional rather than personal interest in these proceedings. The institutional coordination becomes increasingly obvious as the morning progresses. Court staff, defense counsel, and Judge Thornfield operate with the mechanical precision of people implementing established procedures for handling unwanted civil rights cases. Their collaboration extends beyond normal professional courtesy into territory that violates federal civil rights law and judicial ethics requirements. Harper observes this coordination with the detached interest of someone studying institutional corruption for professional purposes. Her legal pad fills with observations that appear routine but actually document systematic constitutional violations affecting every minority plaintiff who seeks federal civil rights protection in this courtroom. Most pro se civil rights plaintiffs display emotional investment in their cases that reflects the personal nature of constitutional violations. They're fighting police brutality, employment discrimination, or voting rights violations that fundamentally change their lives. Harper shows none of this emotional attachment, maintaining clinical observation that suggests professional rather than personal interest in judicial misconduct. Her composure under systematic attack demonstrates either extraordinary self-control or familiarity with hostile legal environments that most citizens would find overwhelming. The distinction matters because self-control can break under sufficient pressure, while professional training provides immunity to intimidation tactics that rely on emotional manipulation. Judge Thornfield crosses the line from bias into constitutional violation with the casual authority of someone accustomed to operating without oversight. She announces her intention to dismiss Harper's case without allowing evidence presentation, violating due process requirements under the 14th Amendment that protect all citizens regardless of race or representation status. I've heard enough preliminary argument to determine this case lacks merit. Motion to dismiss is granted. The ruling violates fundamental principles of federal civil procedure, which require evidence presentation before case dismissal except in extraordinary circumstances that don't exist here. Thornfield's predetermined dismissal constitutes denial of constitutional rights under color of judicial authority, creating federal criminal liability under 18 U.S.C. Section 242. Harper's response demonstrates knowledge that extends far beyond typical pro se representation while maintaining the respectful tone expected from someone challenging judicial authority. Her precision in citing federal rules and constitutional provisions should alert everyone in the courtroom to unusual legal sophistication. Your Honor, plaintiff is entitled to present evidence before dismissal under Federal Rule of Civil Procedure 12 and constitutional due process requirements established in Bell Atlantic v. Twombly. The citation of Supreme Court precedent with precise case names and legal holdings suggests preparation that extends beyond normal pro se research. Harper demonstrates instant familiarity with complex federal jurisprudence that typically requires years of appellate practice to master. Thornfield's response reveals growing frustration with Harper's refusal to accept dismissive treatment without challenge. Most pro se litigants either capitulate to judicial pressure or react emotionally to procedural violations, allowing biased judges to maintain the appearance of legal propriety while systematically denying constitutional protections. Ms. Sterling, don't presume to lecture me on constitutional law. Your understanding of federal procedure is clearly inadequate for the complexities of Section 1983 litigation. This represents pure projection. Thornfield's procedural rulings violate basic federal court requirements established in countless appellate decisions, while Harper's legal knowledge appears encyclopedic. The court reporter's fingers pause over her stenotype machine as she recognizes the irony of a federal judge accusing someone else of procedural ignorance while systematically violating federal civil rights law. Harper produces a copy of the Local Rules of Federal Practice posted outside the courthouse, highlighting Section 3.2 requiring evidence hearings before case dismissal. Her citation demonstrates familiarity with federal court administration that extends beyond single case preparation into comprehensive understanding of judicial procedures. According to Local Rule 3.2, posted in the courthouse entrance, plaintiffs in civil rights cases retain the right to present evidence prior to dismissal for failure to state a claim. The reference to posted court rules neutralizes Thornfield's claim that Harper lacks procedural knowledge while documenting the judge's violation of her own court's published procedures. This type of citation suggests legal research that extends beyond case-specific preparation into systematic study of federal court operations. Under increasing pressure from judicial harassment, most pro se litigants would become flustered, angry, or intimidated by the awesome authority of federal judicial power. Harper responds with citations drawn from memory that demonstrate instant access to complex federal jurisprudence. Title 42, Section 1983, provides civil rights remedies for constitutional violations under color of state law. Federal Rule 12b-6 requires specific pleading standards established in Ashcroft v. Iqbal. Bell Atlantic v. Twombly clarifies that plausibility rather than possibility constitutes the appropriate standard for federal civil rights claims. Her instant recall of case names, citations, and legal holdings suggests daily familiarity with constitutional law rather than case-specific preparation. The precision of her constitutional analysis surpasses that of many practicing civil rights attorneys while maintaining the deferential tone expected from pro se litigants facing federal judicial authority. Defense counsel Ashford objects to Harper's accurate legal citations with increasing desperation, claiming they're inappropriate for pro se representation in an attempt to disqualify competent legal arguments based on the speaker's representation status rather than substantive merit. Your Honor, plaintiff's supposed legal knowledge appears rehearsed rather than genuine. I question whether she's receiving unauthorized assistance in violation of pro se representation requirements. The accusation attempts to criminalize Harper's expertise by suggesting rule violations rather than acknowledging her obvious legal sophistication. Ashford's familiarity with these tactics suggests prior coordination with judicial bias designed to exclude competent legal arguments that threaten predetermined outcomes. Court Clerk Fairbanks discovers additional procedural errors in Harper's filings with timing that suggests coordination rather than coincidental oversight. Her pattern of sabotage includes misfiling evidence, providing incorrect deadlines, and losing documents that support Harper's constitutional claims. Bailiff Camden Pierce positions himself closer to the plaintiff's table with movements that create physical intimidation without legal justification. Harper has demonstrated no threatening behavior, disruptive conduct, or security concerns that would warrant increased security presence. Their coordination demonstrates institutional hostility rather than individual bias, indicating systematic civil rights violations that affect every minority plaintiff seeking federal constitutional protection in this courthouse. The pattern extends beyond personal prejudice into coordinated conspiracy that violates federal civil rights law. Civil rights advocates in the gallery exchange concerned glances as they witness judicial bias that violates even the permissive standards typically applied to prejudiced federal judges. Legal observers begin taking detailed notes, recognizing potential grounds for judicial misconduct complaints and appellate reversal. The audience includes law students, civil rights attorneys, and community activists who monitor federal court proceedings for systematic bias. Their presence should moderate judicial behavior, but Thornfield continues her assault on constitutional procedures with apparent indifference to public scrutiny. Harper requests that all judicial rulings be explicitly stated for the record, forcing court reporter Riley Chambers to transcribe every biased comment and procedural violation. She's creating an appeal-proof record with precision that suggests federal litigation experience extending beyond typical pro se representation. Your Honor, I request that the court's rulings be stated clearly for the stenographic record to ensure accurate appellate review. The request demonstrates understanding of appellate procedures that most pro se litigants lack. Harper's insistence on complete record preservation suggests familiarity with federal appeals that typically requires years of practice to develop. Chambers transcribes the proceedings with growing discomfort as she recognizes the judicial misconduct she's required to document for official court records. Her stenotype machine captures every constitutional violation with precision required for federal appellate review and potential criminal prosecution. Judge Thornfield escalates from professional criticism into personal attack with comments that cross clearly established boundaries of judicial conduct. Federal judges are prohibited from making personal comments about litigants' intelligence, education, or competence under ethical rules designed to preserve judicial neutrality. Ms. Sterling, your apparent familiarity with legal terminology doesn't disguise the fundamental frivolity of your claims. Perhaps you've been watching too much television law. The insult violates judicial conduct standards that prohibit personal attacks on litigants while revealing assumptions about race and education that would horrify civil rights advocates if they understood the systematic nature of such comments in Thornfield's courtroom. Harper accepts the insult without protest, maintaining professional composure that suggests either extraordinary self-control or immunity to intimidation tactics based on professional training. Her refusal to react emotionally disrupts the normal dynamics that allow judicial bias to operate without challenge. Federal investigations can be financially devastating, even when you're innocent. That's where litigation insurance from ARAG comes in. For pennies on the dollar, you can protect yourself from legal costs that could reach hundreds of thousands. ARAG covers attorney fees, court costs, and expert witness fees in over 100 legal situations. Visit arag.com and get a free quote today. Don't let legal bills destroy your life while fighting for justice. This isn't merely employment discrimination litigation conducted in isolation from broader constitutional concerns. Harper's case challenges systemic civil rights violations affecting federal prisoners nationwide, representing broader constitutional issues involving Eighth Amendment prisoner treatment, due process violations, and institutional civil rights policies affecting thousands of federal inmates. The scope of constitutional violations at stake extends far beyond individual employment. Discrimination into systematic institutional failures that affect vulnerable populations nationwide. Harper's case represents a test of federal civil rights enforcement mechanisms designed to protect constitutional rights for all citizens. Judge Thornfield escalates beyond civil case bias into criminal judicial power with threats that demonstrate abuse of constitutional authority. Contempt citations can result in imprisonment and fines imposed without traditional criminal procedure protections, making them particularly vulnerable to abuse by biased judges. Ms. Sterling, I'm ordering you to show cause why you shouldn't be held in contempt of court for continued disrespect of judicial authority. Show cause orders reverse constitutional burden of proof by requiring defendants to prove their innocence rather than requiring prosecution to prove guilt. Thornfield's threat escalates systematic bias into criminal procedure violations that create additional federal civil rights liability. Harper documents this threat with the clinical precision she applies to every procedural violation, maintaining careful records that will support both appellate reversal and potential criminal prosecution of judicial misconduct under federal civil rights law. Legal blog reporters in the gallery recognize a developing story that could generate national media attention if properly documented. Judicial misconduct in federal civil rights cases attracts appellate scrutiny, newspaper coverage, and civil rights organization involvement that threatens judicial careers built on systematic bias. The presence of media observers should moderate judicial behavior, but Thornfield continues escalating constitutional violations with apparent indifference to public scrutiny. Her confidence suggests either profound ignorance of federal oversight mechanisms or belief in immunity from consequences that has been reinforced by years of unchecked authority. Judge Thornfield's conduct violates 18 U.S.C. Section 242, which criminalizes deprivation of constitutional rights under color of legal authority. Her denial of due process, discriminatory treatment based on race, and procedural violations constitute federal crimes punishable by imprisonment up to 10 years and substantial federal civil rights remedies. The criminal liability extends beyond individual misconduct into conspiracy charges that could include court staff and defense counsel who participate in systematic civil rights violations. Federal conspiracy law allows prosecution of all participants regardless of their specific role in constitutional deprivations. Despite facing contempt threats, procedural harassment, and systematic constitutional violations, Harper maintains composure that suggests familiarity with high-pressure legal environments extending far beyond typical civil litigation experience. Her bearing resembles that of attorneys accustomed to federal court practice, prosecutors experienced with constitutional litigation, or federal agents familiar with appellate scrutiny. The distinction matters because emotional resilience can be broken through sufficient pressure, while professional training provides systematic immunity to intimidation tactics that rely on psychological manipulation rather than legal merit. Thornfield's coordination with defense counsel, court staff cooperation with discriminatory procedures, and systematic denial of civil rights protections suggest institutional rather than individual bias, requiring federal investigation and oversight to restore constitutional compliance. The pattern extends across multiple cases, different plaintiffs, and various constitutional violations, indicating systematic institutional failure rather than isolated incidents of individual prejudice. This scope of misconduct requires federal intervention beyond simple appellate reversal. The morning's proceedings transform into a masterclass in judicial bias as Thornfield escalates from microaggressions into overt constitutional violations. She uses Harper as a teaching example of presumed pro se incompetence, addressing the gallery rather than limiting her comments to legal rulings. Ladies and gentlemen, observe what happens when unqualified individuals attempt to practice law in federal court. Ms. Sterling represents the dangerous trend of pro se litigation wasting judicial resources. This public humiliation violates judicial ethics, requiring respectful treatment of all litigants regardless of representation status. Thornfield transforms constitutional litigation into performative degradation designed to discourage other potential civil rights plaintiffs from seeking federal protection. Court Clerk Fairbanks reinforces the attack with suggestions that appear helpful but actually compound accusations of incompetence. Her coordinated assault demonstrates institutional policy rather than individual concern, revealing how court staff participate in systematic discrimination against civil rights plaintiffs. Judge, perhaps Ms. Sterling would benefit from representation by qualified counsel more familiar with federal procedure. The suggestion implies that constitutional rights become invalid when asserted by citizens without law degrees, contradicting fundamental principles of democratic access to federal courts. Fairbanks's coordination with judicial bias suggests systematic training and techniques for frustrating civil rights litigation. Harper responds to public humiliation with professional grace that should alert observers to her unusual preparation for these proceedings. Most pro se litigants would react emotionally to such treatment, either through anger or submission that allows biased judges to maintain control of courtroom dynamics. Your Honor, I respectfully submit that federal civil rights violations merit judicial consideration regardless of plaintiff's representation status. The response demonstrates legal sophistication combined with appropriate deference to judicial authority. Harper's ability to maintain professional composure under systematic attack suggests either extraordinary personal discipline or professional training in managing hostile legal environments. When Thornfield challenges her understanding of constitutional law with demands that exceed reasonable expectations for pro se litigants, Harper recites from memory complex federal jurisprudence with precision that surpasses many practicing civil rights attorneys. Title 42, Section 1983 provides that every person who, under color of state law, subjects any citizen to deprivation of constitutional rights shall be liable to the party injured. Harlow v. Fitzgerald established that qualified immunity shields officials unless they violated clearly established law that reasonable officials would have known. Her instant access to case names, legal citations, and precise holdings suggests daily familiarity with constitutional law rather than case-specific research. The level of expertise demonstrates preparation that extends far beyond typical employment discrimination litigation. Legal observers in the gallery exchange meaningful glances as Harper continues demonstrating constitutional knowledge that contradicts all assumptions about pro se competence. Her precise citations, accurate legal standards, and sophisticated understanding of federal civil rights jurisprudence suggest preparation that extends into professional territory. Defense attorney Ashford escalates his attacks on Harper's competence with accusations designed to disqualify legal expertise, rather than address substantive constitutional arguments. His coordination with judicial bias suggests prior planning rather than spontaneous courtroom advocacy. Your Honor, plaintiff's supposed legal knowledge appears rehearsed rather than genuine. I question whether she's receiving unauthorized assistance in violation of pro se representation requirements. The accusation attempts to criminalize competent legal argument by suggesting rule violations rather than acknowledging obvious legal sophistication. Ashford's desperation increases as Harper's expertise threatens the predetermined narrative of pro se incompetence that justifies dismissing civil rights cases without serious consideration. Harper ensures that every inappropriate judicial comment, procedural violation, and constitutional infringement is explicitly stated for stenographic transcription. Her insistence on complete record preservation suggests appellate experience and understanding of federal court review standards that extend beyond typical pro se knowledge. The official court record now contains comprehensive documentation of civil rights violations, judicial bias, and institutional discrimination suitable for federal appellate review and potential criminal prosecution. Harper's systematic record creation suggests familiarity with federal litigation standards that typically require years of practice to master. The gallery divides between those supporting institutional authority and those recognizing constitutional violations, as Harper's case exposes systematic bias that affects all minority plaintiffs seeking federal civil rights protection. Legal observers document judicial misconduct while court staff demonstrate loyalty to institutional hierarchy. This division reflects broader tensions between constitutional compliance and institutional protection that characterize federal courts struggling with civil rights enforcement. The conflict becomes visible when systematic bias faces competent challenge rather than operating without scrutiny. Court reporter Chambers asks whether judicial personal attacks should be included in official transcripts, highlighting the problematic nature of Thornfield's behavior. Court reporters typically transcribe proceedings without editorial comment, but judicial misconduct creates professional ethical dilemmas for staff required to document constitutional violations. Judge, should I include your personal comments about the plaintiff's competence in the official transcript? The question forces Thornfield to acknowledge that her comments exceed appropriate judicial discourse, while creating official record of misconduct suitable for appellate review and judicial discipline proceedings. Judge Thornfield escalates beyond case-specific bias into institutional retaliation with threats designed to pursue consequences extending beyond the immediate litigation. Federal court administrators handle serious procedural violations, ethics complaints, and attorney discipline that could affect Harper's future access to federal courts. Ms. Sterling, I'm considering reporting your conduct to the federal court administrator for investigation of possible pro-representation violations and potential sanctions. The threat demonstrates intent to weaponize federal administrative machinery against constitutional plaintiffs who refuse to accept dismissive treatment without challenge. Thornfield's escalation reveals panic rather than judicial authority, as Harper's competence threatens predetermined outcomes. Harper documents this threat without protest, maintaining careful records that will support both constitutional claims and potential judicial misconduct complaints. Her clinical documentation suggests familiarity with federal oversight mechanisms that most pro se litigants lack. Thornfield demands demonstration of legal expertise that would challenge experienced federal practitioners, requiring Harper to recite complex constitutional doctrine, typically requiring years of specialized education and practice to master. Before proceeding further, I require you to demonstrate familiarity with Federal Rule 26 discovery requirements, Rule 56 summary judgment standards, and the complete framework of Title VII intersectional analysis under Crenshaw v. DeGraffenreid. This professional hazing exceeds all reasonable expectations for pro se representation, demanding expertise typically available only to attorneys with federal court experience and specialized civil rights training. Thornfield's requirements constitute judicial abuse designed to exclude constitutional claims based on representation status rather than legal merit. Harper's response demonstrates not merely legal knowledge but sophisticated understanding of federal civil rights theory, constitutional analysis, and complex procedural requirements that reveal preparation extending far beyond typical employment discrimination litigation. Rule 26 requires automatic disclosure of basic discovery materials within 14 days of defendant's answer. Rule 56 permits summary judgment only when no genuine dispute of material fact exists and moving party is entitled to judgment as matter of law. Intersectional analysis under Crenshaw requires examination of multiple discrimination categories affecting individual plaintiffs rather than treating race and gender as separate analytical frameworks. The precision of her response exceeds expectations for practicing civil rights attorneys while maintaining appropriate respect for judicial authority. Harper's expertise suggests professional legal training combined with specialized civil rights knowledge that extends beyond typical federal practice. When Thornfield demands citation of specific federal appellate decisions, Harper provides not only case names and legal citations but detailed holdings, procedural histories, and distinguishing factors that demonstrate encyclopedic knowledge of federal civil rights jurisprudence. In McDonnell Douglas v. Green, 411 U.S. 792, the Supreme Court established burden-shifting framework for employment discrimination claims. Plaintiff establishes prima facie case through evidence of protected class membership, qualification for position, adverse employment action, and circumstances suggesting discrimination. Defendant must then articulate legitimate non-discriminatory reason for adverse action. Plaintiff may prove pretext through evidence that stated reason is false or that discrimination was more likely motivation. Her instant recall of complex constitutional doctrine with precise procedural details suggests daily familiarity with federal civil rights law rather than case-specific preparation. The level of expertise indicates professional background in constitutional enforcement that extends far beyond typical pro se representation. Court staff coordination becomes increasingly obvious as proceedings continue with mechanical precision designed to frustrate constitutional litigation. Court Clerk Fairbanks, Bailiff Pierce, and Defense Attorney Ashford operate with choreographed coordination that suggests institutional policy rather than coincidental bias. Their cooperation includes procedural harassment, evidence manipulation, intimidation tactics, and coordinated legal arguments designed to exclude constitutional claims based on representation status rather than substantive merit. The pattern indicates systematic training and techniques for frustrating civil rights litigation. 3 individuals in conservative business attire enter the gallery and take seats with direct view of judicial proceedings. They carry identical folders, maintain professional bearing, and observe with intensity, suggesting official rather than casual interest in the proceedings. Their synchronized arrival generates subtle tension among court staff who recognize the bearing of federal officials conducting oversight rather than routine court observation. The presence of potential federal investigators should moderate judicial behavior. But Thornfield continues constitutional violations with apparent indifference to official scrutiny. Judge Thornfield demonstrates increasing uncertainty about her procedural rulings as Harper continues providing accurate legal citations that contradict judicial assertions and expose procedural errors that could generate appellate reversals and judicial discipline complaints. Her confidence wavers when faced with precise constitutional knowledge that reveals the gap between her assumptions about pro se competence and the reality of Harper's expertise. The cognitive dissonance threatens the predetermined narrative that justifies dismissing civil rights cases without serious consideration. Harper formally requests judicial recusal under federal statute requiring judges to remove themselves from cases where impartiality might reasonably be questioned. Her motion cites specific instances of demonstrated bias and prejudice that violate constitutional due process requirements. Under 28 U.S.C. Section 455, I move for judicial recusal based on demonstrated bias and prejudice affecting constitutional due process rights guaranteed under the 14th Amendment. The motion demonstrates understanding of federal recusal requirements combined with precise legal citations that force Thornfield to address her obvious bias rather than continuing to operate under the pretense of judicial neutrality. Federal law requires judges to recuse themselves when personal bias affects their ability to provide constitutionally required impartial proceedings. Thornfield's documented pattern of discriminatory treatment creates legal obligation for recusal that she cannot ignore without additional federal law violations. Thornfield's threat of contempt imprisonment violates due process requirements by failing to specify contemptuous conduct, provide adequate warning, or allow defendant response before imposing criminal sanctions. Her abuse of contempt power constitutes additional federal civil rights violation. Ms. Sterling, your continued challenges to judicial authority constitute contempt of court. I'm considering immediate imprisonment for disruptive behavior and disrespect. Contempt proceedings require specific findings of disruptive conduct that interferes with court proceedings. Harper has been respectful, procedurally correct, and substantively accurate in her legal arguments. Thornfield's threat represents retaliation for competent constitutional advocacy rather than legitimate contempt enforcement. Bailiff Pierce creates physical intimidation without legal justification by positioning himself near the plaintiff's table with instructions designed to suggest security threats that don't exist. Harper has demonstrated no threatening behavior, disruptive conduct, or security concerns warranting increased law enforcement presence. Ma'am, please remain seated and avoid sudden movements. The instruction creates atmosphere of criminal enforcement rather than civil litigation while suggesting that Harper poses security risks based solely on her race and refusal to accept dismissive treatment without constitutional challenge. Harper observes Pierce's positioning with awareness that suggests security training or law enforcement experience extending beyond typical civilian knowledge. Her evaluation of tactical positioning, threat assessment, and defensive options demonstrates preparation that most pro se litigants lack. The distinction between civilian anxiety and professional security awareness becomes apparent in Harper's systematic evaluation of courtroom dynamics, rather than emotional reaction to intimidation tactics. Her clinical assessment suggests familiarity with law enforcement procedures that extends beyond typical civil litigation experience. The three federal observers document judicial proceedings with precision, suggesting official investigation rather than academic research. Their synchronized note-taking, professional coordination, and focused attention on judicial conduct indicates federal oversight activity that could result in disciplinary proceedings and criminal prosecution. Their presence represents potential federal intervention in systematic civil rights violations that have operated without oversight for years. Court staff recognition of federal authority creates tension that threatens the institutional conspiracy against constitutional compliance. Court reporter Chambers transcribes every judicial threat, procedural violation, and constitutional infringement with precision required for federal appellate review and potential criminal prosecution. The official court record now contains comprehensive documentation of judicial misconduct suitable for federal enforcement action. The stenographic record provides evidence that meets federal prosecution standards for civil rights violations under color of legal authority, conspiracy against constitutional rights, and systematic institutional discrimination affecting protected classes of federal court users. Thornfield's final threat attempts to invoke federal oversight that she cannot control, demonstrating panic rather than judicial authority as her systematic bias faces competent challenge backed by potential federal investigation. I'm considering referral of this matter to the chief judge of this district for investigation of abuse of federal court process. The threat backfires by acknowledging federal oversight mechanisms that investigate judicial misconduct rather than plaintiff behavior. Chief judges handle constitutional violations by federal judges, not civil rights advocacy by constitutional plaintiffs. Harper's case has successfully documented 18 months of systematic civil rights violations affecting dozens of minority plaintiffs while exposing institutional conspiracy that extends beyond individual judicial bias into coordinated constitutional deprivation, requiring federal intervention and criminal prosecution. The morning that began with routine civil rights litigation has evolved into comprehensive federal evidence gathering that will reshape civil rights enforcement across the district while potentially sending respected federal officials to prison for constitutional violations under color of legal authority. As the clock approaches 11:45 a.m., the stage is set for federal intervention that will transform not just this case, but the entire institutional culture that has protected systematic bias through coordinated intimidation, procedural manipulation, and constitutional violation designed to deny equal protection under law to citizens seeking federal civil rights protection. The next 90 minutes will determine whether institutional authority can continue operating without constitutional compliance, or whether federal law enforcement will impose consequences that restore equal justice under law for all citizens regardless of race, representation status, or willingness to challenge systematic bias through competent constitutional advocacy. The atmosphere in courtroom 3A shifts like barometric pressure before a storm as Harper Sterling maintains her professional composure despite facing the full weight of federal judicial authority wielded with systematic bias. Judge Victoria Thornfield's threats of contempt and imprisonment represent the culmination of 18 months of documented civil rights violations, but what neither she nor her co-conspirators realize is that federal law enforcement has been building a comprehensive case that extends far beyond today's proceedings. Harper formally requests judicial recusal under federal statute, requiring judges to remove themselves from cases where impartiality might reasonably be questioned, forcing Thornfield to confront the obvious bias that has characterized every moment of these proceedings. Under 28 U.S.C. Section 455, I move for judicial recusal based on demonstrated bias, personal prejudice, and systematic denial of constitutional due process rights guaranteed under the 14th Amendment to all citizens regardless of race or representation status. The motion demonstrates sophisticated understanding of federal recusal requirements combined with precise legal citations that create official record of judicial misconduct. Harper's language carries the precision of someone intimately familiar with federal oversight mechanisms designed to ensure constitutional compliance in federal courts. Thornfield's face flushes red as the implications of Harper's motion penetrate her consciousness. Recusal motions force judges to examine their own conduct rather than simply dismissing constitutional challenges, creating uncomfortable self-reflection that reveals the gap between required judicial neutrality and her systematic bias against minority plaintiffs. Motion denied. This court finds no evidence of bias or prejudice in applying standard federal court procedures to all litigants equally. The denial violates federal law requiring recusal when impartiality might reasonably be questioned. Thornfield's documented pattern of discriminatory treatment, personal attacks, and procedural violations creates clear evidence of bias that federal appellate courts would recognize immediately upon review. Harper documents the denial with clinical precision, adding another federal law violation to the comprehensive record she has created for appellate review and potential criminal prosecution. Her systematic documentation suggests familiarity with federal enforcement mechanisms that extends beyond typical civil litigation experience. Defense attorney Wells Ashford escalates his coordination with judicial bias through objections designed to exclude constitutional arguments based on representation status rather than legal merit. His desperation increases as Harper's competence threatens the predetermined outcome that his collaboration with Thornfield was designed to achieve. Your Honor, plaintiff's continued legal arguments exceed the scope of pro se representation. I move to strike all constitutional analysis as inappropriate for self-represented litigants. The motion attempts to exclude competent legal argument by suggesting that constitutional rights become invalid when asserted by citizens without law degrees. Ashford's coordination with systematic bias reveals institutional conspiracy that violates federal civil rights law and legal ethics requirements. Thornfield grants the motion with enthusiasm that betrays her relief at finding procedural justification for excluding Harper's devastating constitutional analysis. Her ruling violates fundamental principles of democratic access to federal courts that protect constitutional rights regardless of representation status. Granted, Mr. Sterling, confine your arguments to simple factual statements rather than legal conclusions that exceed your qualifications. The ruling creates appealable error while documenting additional evidence of systematic bias against pro se civil rights plaintiffs. Harper's constitutional expertise threatens the narrative of incompetence that justifies dismissing civil rights cases without serious consideration of their substantive merit. Court Clerk Lila Fairbanks demonstrates coordinated sabotage through administrative errors that consistently favor institutional authority over constitutional compliance. Her pattern of document mishandling, deadline manipulation, and evidence loss reveals systematic training and techniques for frustrating civil rights litigation. Ms. Sterling, I'm afraid your constitutional brief was never properly filed with the court. You'll need to resubmit with correct formatting and service requirements. The claim contradicts Harper's meticulous documentation of every filing, which includes certified mail receipts, electronic confirmation, and witness verification of court submission. Fairbanks's assertion represents either systematic incompetence or coordinated conspiracy to deny constitutional protections through procedural manipulation. Harper produces her filing receipts with movements that suggest familiarity with evidence preservation rather than desperate scrambling typical of pro se litigants facing systematic sabotage. Her organized documentation indicates preparation for exactly this type of institutional resistance. Your Honor, I have certified mail receipt, electronic filing confirmation, and court clerk timestamp verification of proper submission within required deadlines. The comprehensive documentation exposes Fairbanks's sabotage while creating additional evidence of institutional conspiracy against constitutional compliance. Harper's systematic record-keeping suggests professional experience with hostile legal environments that require defensive documentation. Bailiff Camden Pierce creates physical intimidation through tactical positioning designed to suggest security threats that don't exist based on any objective assessment of Harper's behavior. His instructions carry implications of potential violence that transform civil litigation into criminal enforcement atmosphere. Ma'am, I need you to keep your hands visible and avoid reaching into your briefcase without permission. The instruction treats Harper as potential security threat despite her consistent respectful behavior and complete compliance with all legitimate court procedures. Pierce's positioning reflects racial profiling rather than legitimate security assessment, creating additional civil rights violations. Harper complies with the instruction while observing Pierce's tactical positioning with awareness that suggests security training or law enforcement experience. Her evaluation of defensive options, escape routes, and threat assessment demonstrates preparation that most civilians lack. The distinction between nervous compliance and professional assessment becomes apparent in Harper's systematic evaluation of security dynamics rather than emotional reaction to intimidation tactics. Her clinical observation suggests familiarity with law enforcement procedures that extends beyond typical civil litigation experience. Judge Thornfield thinks she has all the power, but she's about to learn she's been bullying the wrong person. What happens next will shock you to your core. Don't even think about clicking away, because the reveal that's coming will leave you speechless. The three federal observers in conservative business attire demonstrate synchronized documentation that suggests official investigation rather than casual court monitoring. Their professional bearing, identical materials, and focused attention on judicial conduct indicates federal oversight activity that threatens the institutional conspiracy Harper faces. Federal Observer Nash Brennan makes discreet contact with court security to establish federal authority for monitoring judicial proceedings. His presentation of federal credentials to courthouse administration creates tension among court staff who recognize the implications of federal oversight. We're conducting authorized federal monitoring of civil rights compliance pursuant to Administrative Office of U.S. Courts Investigation Authority. The announcement transforms the courtroom atmosphere from local judicial authority into federal law enforcement territory. Court staff recognition of federal oversight creates visible anxiety among participants in systematic constitutional violations. Federal Observer Quinn Draper documents specific instances of procedural violations, constitutional infringements, and civil rights deprivations with precision that suggests preparation for federal prosecution rather than administrative review. Her systematic evidence gathering indicates serious federal enforcement action. The coordination between federal observers suggests comprehensive investigation that extends beyond today's proceedings into pattern analysis of systematic constitutional violations affecting multiple plaintiffs over extended time periods. Their presence indicates federal commitment to civil rights enforcement that threatens careers built on systematic bias. Judge Thornfield recognizes federal authority with growing panic that contradicts her previous confidence in institutional immunity from constitutional compliance. Her awareness of federal oversight mechanisms reveals understanding that systematic bias violates federal law despite years of operating without consequences. What authority do federal observers have to monitor ongoing court proceedings? The question demonstrates Thornfield's desperate search for procedural grounds to exclude federal oversight that threatens her systematic constitutional violations. Her panic suggests awareness that federal investigation could result in criminal prosecution rather than administrative discipline. Federal Observer Paige Sinclair presents comprehensive federal authority for civil rights monitoring under statutory provisions that supersede local judicial control when constitutional violations create federal enforcement priorities. Federal oversight operates under 28 U.S.C. Section 372, investigating judicial misconduct, 42 U.S.C. Section 1983, civil rights enforcement, and 18 U.S.C. Section 242, criminal civil rights violations. The citation of criminal statutes creates immediate threat of federal prosecution that transforms systematic bias from career risk into potential imprisonment. Sinclair's reference to criminal law enforcement indicates that federal investigation extends beyond administrative discipline into criminal justice territory. Harper observes the federal observers with recognition that suggests professional familiarity rather than civilian curiosity about federal authority. Her assessment of their procedures, documentation methods, and coordination indicates understanding of federal law enforcement operations. The distinction between civilian observation and professional recognition becomes apparent in Harper's systematic evaluation of federal procedures rather than emotional relief at potential rescue from systematic bias. Her clinical assessment suggests personal experience with federal law enforcement operations. Want to understand federal law like Agent Cross? The Constitution Institute offers online courses taught by former FBI agents and federal prosecutors. Learn about civil rights, criminal procedure, and federal jurisdiction. Use promo code JUSTICE50 at constitutioninstitute.edu for 50% off your first course. Knowledge of federal law is your best defense against those who would abuse their power. Federal Observer Brennan announces that today's proceedings are being recorded under Federal Investigation Authority, transforming every word and gesture into potential evidence for criminal prosecution and appellate review. The announcement creates comprehensive documentation that eliminates deniability for systematic constitutional violations. Please be advised that these proceedings are being recorded pursuant to Federal Civil Rights Investigation Authority under Department of Justice oversight. The recording announcement forces all participants to acknowledge that their conduct faces federal scrutiny rather than operating under local immunity from constitutional compliance. Brennan's authority supersedes judicial control of courtroom procedures when federal civil rights violations create law enforcement priorities. Judge Thornfield objects to federal recording with desperation that reveals her awareness of criminal liability for systematic constitutional violations documented in today's proceedings. Her objection demonstrates understanding that federal evidence gathering threatens personal freedom rather than merely professional reputation. I object to unauthorized recording of judicial proceedings without court approval. The objection misunderstands federal law enforcement authority that operates independently of judicial control when investigating constitutional violations by federal officials. Thornfield's desperate attempt to control federal evidence gathering reveals panic rather than legitimate procedural concern. Federal Observer Draper presents statutory authority for federal recording that supersedes judicial objections when systematic civil rights violations create federal enforcement priorities requiring comprehensive documentation for prosecution and pattern analysis. Federal recording operates under Department of Justice authority investigating civil rights violations. Judicial consent is not required for federal law enforcement operations. The clarification establishes federal supremacy over local judicial authority when constitutional violations create federal enforcement priorities. Draper's citation of Department of Justice authority indicates that investigation extends to highest levels of federal law enforcement. Court reporter Riley Chambers asks whether federal recording affects her stenographic responsibilities, highlighting the intersection between local court procedures and federal law enforcement operations that create competing documentation requirements. Should I continue official transcription while federal recording is in progress? The question forces acknowledgement of dual documentation systems that create comprehensive evidence for both appellate review and criminal prosecution. Chambers' concern reveals professional anxiety about participating in proceedings that face federal criminal investigation. Federal evidence demonstrates coordination between Judge Thornfield, Court Clerk Fairbanks, Defense Attorney Ashford, and Bailiff Pierce to frustrate civil rights litigation through procedural harassment, evidence manipulation, and intimidation tactics that violate federal conspiracy laws. Our investigation reveals systematic coordination to deny constitutional protections to minority plaintiffs through procedural manipulation and institutional bias. Federal Observer Sinclair's announcement exposes the institutional conspiracy that Harper has documented through her systematic record keeping. The pattern evidence indicates criminal coordination rather than individual bias, creating federal conspiracy liability for all participants. Defense Attorney Ashford attempts to distance himself from systematic bias through claims of independent legal judgment, but his coordination with judicial prejudice throughout today's proceedings contradicts assertions of professional independence. Your Honor, my representation has been conducted according to standard federal court practice without coordination with court personnel. The denial contradicts obvious evidence of coordination including synchronized objections, procedural collaboration, and strategic coordination designed to exclude constitutional arguments based on representation status rather than legal merit. Harper documents Ashford's denial while maintaining her systematic record of institutional conspiracy that creates federal criminal liability under conspiracy statutes targeting coordinated civil rights violations. Her documentation provides evidence that meets federal prosecution standards. When federal investigators address Harper, their tone shifts to professional respect rather than dismissive treatment typical for pro se plaintiffs, suggesting recognition of her professional status despite her current representation as self-represented litigant. Ms. Sterling, we appreciate your cooperation with federal investigation procedures and your systematic documentation of constitutional violations. The professional courtesy indicates familiarity with Harper's background that extends beyond today's proceedings. Federal Observer Sinclair's tone suggests prior knowledge of Harper's qualifications rather than surprise at her competence. Harper responds with professional acknowledgement that maintains her cover as pro se litigant, while demonstrating comfort with federal authority that suggests personal familiarity with law enforcement operations. I'm committed to supporting constitutional compliance and federal civil rights enforcement through whatever cooperation is appropriate. The response maintains appropriate distance while indicating understanding of federal procedures that extends beyond typical civilian knowledge. Harper's comfort with federal authority suggests professional experience with law enforcement cooperation. News reporters alerted by federal courthouse activity gather in hallways as word spreads of potential judicial misconduct investigation involving systematic civil rights violations. Federal judicial corruption generates national media attention that threatens careers built on local immunity from oversight. Legal bloggers and civil rights advocates monitor developing story through social media and courthouse sources, recognizing potential precedent-setting case of federal intervention in systematic judicial bias affecting constitutional protections for minority plaintiffs. The media attention creates additional pressure for federal action while documenting public interest in constitutional compliance that extends beyond local judicial politics. National coverage threatens institutional protection that has allowed systematic bias to operate without consequences. Judge Thornfield recognizes that federal investigation combined with media attention threatens not just her career, but potential criminal prosecution that could result in imprisonment and permanent federal criminal record. Her panic increases as the scope of federal authority becomes apparent. This federal intervention exceeds appropriate oversight authority and interferes with legitimate judicial proceedings. The objection mischaracterizes federal civil rights enforcement as interference rather than constitutional obligation. Thornfield's desperate attempt to limit federal authority reveals understanding that systematic bias violates federal law despite years of institutional protection. Federal investigators present comprehensive evidence file containing 18 months of surveillance, pattern analysis, statistical documentation, and witness statements demonstrating systematic civil rights violations requiring federal intervention and potential criminal prosecution. Statistical analysis demonstrates discriminatory patterns affecting 47 minority plaintiffs over 18 months, with case dismissal rates of 87% compared to 12% for similar cases involving white plaintiffs. Federal Observer Draper's statistical evidence provides overwhelming proof of systematic discrimination that violates equal protection guarantees under the 14th Amendment. The pattern evidence meets federal standards for both criminal prosecution and comprehensive institutional intervention. The statistical documentation exposes systematic bias as institutional policy rather than individual prejudice, creating federal pattern and practice case that requires comprehensive intervention extending beyond individual accountability to institutional reform and federal oversight. Harper observes the statistical presentation with professional interest rather than personal vindication, suggesting familiarity with federal pattern analysis that extends beyond individual case experience. Her clinical assessment indicates understanding of federal enforcement procedures. Federal Observer Brennan presents evidence of systematic coordination designed to frustrate constitutional litigation through procedural harassment, evidence manipulation, and intimidation tactics that create federal conspiracy liability for institutional participants. Documentary evidence demonstrates coordinated effort to deny constitutional protections through systematic procedural violations, evidence tampering, and witness intimidation affecting protected classes of federal court users. The conspiracy evidence transforms individual misconduct into institutional criminal liability that extends to all participants in systematic constitutional violations. Brennan's evidence meets federal prosecution standards for conspiracy charges carrying significant imprisonment. Court Clerk Fairbanks attempts to minimize her participation through claims of routine administrative functions, but her systematic sabotage of constitutional litigation contradicts assertions of neutral administrative support. I've performed standard clerk duties according to established court procedures without bias toward any particular litigant. The denial contradicts comprehensive documentation of systematic sabotage, including document mishandling, deadline manipulation, and evidence loss that consistently favors institutional authority over constitutional compliance. Federal Observer Sinclair presents evidence of Fairbanks's coordination with systematic bias through pattern analysis demonstrating that administrative errors consistently disadvantage minority plaintiffs while supporting institutional authority. Administrative analysis reveals systematic pattern of procedural errors affecting minority civil rights plaintiffs at rates statistically impossible through random occurrence. The pattern evidence exposes administrative sabotage as coordinated policy rather than clerical error, creating criminal liability for conspiracy to violate civil rights under color of administrative authority. Bailiff Pierce faces federal documentation of systematic intimidation tactics designed to discourage constitutional advocacy through physical presence and implied threats that violate federal civil rights law protecting access to federal courts. Security analysis demonstrates systematic use of intimidation tactics targeting minority plaintiffs without objective security justification based on behavioral assessment. Federal Observer Draper's security analysis exposes Pierce's intimidation as racial profiling rather than legitimate security procedure, creating federal civil rights liability for systematic constitutional violations under color of law enforcement authority. If this story of federal justice served cold amazed you, wait until you hear about the corrupt sheriff who arrested a Supreme Court justice's son. That story is even more shocking. Subscribe and ring that bell so you never miss these incredible true stories of justice. Chief Judge Evelyn Blackwood arrives with United States Marshals, indicating escalation to highest federal court authority combined with federal law enforcement capability. Her presence confirms federal rather than local resolution while providing arrest authority for potential criminal charges. I'm assuming jurisdiction over these proceedings under federal judicial oversight authority, pursuant to reports of systematic constitutional violations affecting civil rights compliance. Blackwood's intervention represents federal judicial authority superseding local control when systematic bias threatens constitutional compliance. Her coordination with federal marshals indicates potential criminal enforcement rather than merely administrative discipline. United States Marshals establish federal law enforcement presence with authority for arrest, prisoner transport, and judicial security that transforms civil proceedings into potential criminal justice operations. Their presence indicates serious federal commitment to constitutional enforcement. The Marshals position themselves strategically throughout the courtroom with professional bearing that suggests preparation for federal arrest procedures rather than routine court security. Their federal authority supersedes local law enforcement when constitutional violations create federal priorities. Judge Thornfield recognizes federal marshal authority with terror that contradicts her previous confidence in institutional immunity. Her understanding of federal arrest powers reveals awareness that systematic bias violates criminal law despite years of operating without consequences. What authority do federal marshals have in ongoing civil proceedings? The question demonstrates Thornfield's desperate search for procedural protection from federal criminal enforcement that threatens imprisonment rather than administrative discipline. Her panic reveals understanding that systematic constitutional violations create criminal liability. Chief Judge Blackwood explains federal marshal authority for enforcing constitutional compliance when systematic violations require immediate intervention to protect federal civil rights guarantees for all citizens regardless of local institutional resistance. Federal marshals enforce constitutional compliance when systematic violations threaten civil rights protections guaranteed under federal law. Criminal enforcement operates independently of local judicial control. The explanation establishes federal supremacy over local authority when constitutional violations create federal enforcement priorities requiring immediate intervention to restore equal protection under law for affected citizens. Harper observes federal marshal procedures with professional recognition rather than civilian relief, suggesting personal familiarity with federal law enforcement operations that extends beyond today's proceedings. Her assessment indicates understanding of arrest procedures and federal authority. The distinction between civilian observation and professional recognition becomes apparent in Harper's systematic evaluation of federal procedures rather than emotional response to potential rescue from systematic bias. Federal investigators present comprehensive evidence requiring immediate federal intervention to prevent continued constitutional violations while preserving evidence for criminal prosecution and comprehensive institutional reform. Evidence supports immediate suspension of judicial authority pending federal investigation, criminal referral to United States Attorney, and comprehensive institutional oversight to restore constitutional compliance. Federal Observer Brennan's recommendation represents serious federal commitment to constitutional enforcement that threatens not just careers but personal freedom for participants in systematic civil rights violations. Judge Thornfield faces the devastating realization that 18 months of systematic bias has created federal criminal liability extending beyond professional consequences into potential imprisonment for civil rights violations under color of judicial authority. This federal intervention exceeds constitutional authority and violates judicial independence protected under federal law. The objection mischaracterizes federal civil rights enforcement as constitutional violation rather than constitutional obligation. Thornfield's desperate appeal to judicial independence contradicts systematic bias that violates judicial oath to uphold constitutional protections. Chief Judge Blackwood explains that judicial independence protects legitimate judicial function but provides no immunity from criminal prosecution when systematic constitutional violations require federal enforcement action. Judicial independence protects legitimate constitutional functions, but provides no immunity from federal criminal prosecution for systematic civil rights violations under color of judicial authority. The clarification eliminates Thornfield's final defense while establishing federal authority for criminal prosecution that operates independently of judicial protection when constitutional violations create federal enforcement priorities. Federal evidence compilation reaches comprehensive scope requiring immediate action to prevent continued constitutional violations while preserving evidence for criminal prosecution that meets federal standards for conspiracy charges and civil rights violations. The moment of revelation arrives with precision that transforms 18 months of systematic investigation into decisive federal action. Harper Sterling reaches into her briefcase not for additional legal documents but for credentials that will shatter every assumption about her identity and authority. The black leather credential case emerges with federal insignia that immediately silences the courtroom. Judge Thornfield's face drains of color as she recognizes the gold emblem of the Federal Bureau of Investigation, realizing that the woman she has systematically insulted and threatened represents federal law enforcement authority. Your Honor, I am Special Agent Harper Sterling, Federal Bureau of Investigation, Civil Rights Division. Badge number 7759. The words hang in the air like a death sentence for systematic bias that has operated under assumption of immunity from federal oversight. Harper's federal credentials transform every insult, threat, and constitutional violation into evidence for criminal prosecution. Harper presents her FBI identification with federal authority that instantly reverses courtroom power dynamics. Judge Thornfield, moments ago wielding absolute judicial power, now faces a federal law enforcement officer she has publicly insulted, threatened with imprisonment, and denied constitutional rights. The transformation from pro se plaintiff to federal agent represents the ultimate revelation of institutional vulnerability to federal enforcement when systematic bias violates constitutional protections guaranteed under federal civil rights law. Chief Judge Blackwood requests federal authentication for court record verification, creating official documentation of Harper's FBI status that eliminates any possibility of denial or procedural challenge to federal authority. Agent Sterling, please provide federal identification authentication for official court record verification. Harper's response demonstrates federal authority that supersedes local judicial control when constitutional violations create federal enforcement priorities, requiring immediate intervention and potential criminal prosecution. Special Agent Harper Sterling, Federal Bureau of Investigation Identification 7759, Civil Rights Division, issued under federal authority by FBI Director pursuant to federal law enforcement authorization under Department of Justice oversight. The comprehensive authentication establishes Harper's federal authority for investigating constitutional violations, conducting federal surveillance, and pursuing criminal prosecution that operates independently of local judicial immunity. United States Marshal Dean Foster acknowledges Special Agent Sterling with professional respect reserved for federal colleague ways, confirming her authority while demonstrating law enforcement coordination required for complex civil rights investigations. Agent Sterling, federal marshals are prepared to assist with any federal law enforcement requirements pursuant to civil rights investigation authority. The professional recognition confirms Harper's federal status while establishing coordination between federal agencies required for comprehensive constitutional enforcement extending beyond individual accountability to institutional reform. Gallery reaction erupts in shocked murmurs as observers realize they have witnessed a federal civil rights investigation unfold in real time. Legal reporters scramble to document unprecedented scene of FBI agent conducting undercover investigation of judicial misconduct during active court proceedings. She's been FBI this whole time. Judge Thornfield insulted a federal agent conducting civil rights investigation. The realization transforms systematic bias from local judicial politics into national civil rights story with implications extending far beyond individual accountability to institutional reform and federal oversight. Judge Thornfield's desperate denial demonstrates disconnect from federal law enforcement reality, while revealing panic at discovering her systematic bias has targeted federal law enforcement conducting authorized civil rights investigation. This is impossible. Federal agents don't conduct undercover civil rights investigations in federal court proceedings. The denial contradicts established FBI authority for investigating constitutional violations wherever they occur, including federal courtrooms where systematic bias threatens civil rights protections guaranteed under federal law. Special Agent Sterling explains federal law enforcement authority for investigating constitutional violations through any means necessary to document systematic bias and preserve evidence for criminal prosecution and institutional reform. Federal Bureau of Investigation conducts civil rights investigations wherever constitutional violations occur, including federal courtrooms where systematic bias threatens equal protection under law guaranteed to all citizens. The explanation establishes comprehensive federal authority that eliminates any procedural protection for systematic constitutional violations while confirming criminal liability for documented civil rights deprivations. Special Agent Sterling presents evidence demonstrating how every judicial insult, procedural violation, and constitutional deprivation was documented for federal prosecution through sophisticated surveillance equipment and systematic record-keeping. Federal investigation documented systematic civil rights violations including due process denial, equal protection violations, and conspiracy to deprive constitutional rights under color of judicial authority affecting 47 minority plaintiffs. The comprehensive evidence creates federal criminal case meeting prosecution standards for conspiracy charges, civil rights violations, and institutional corruption requiring immediate federal intervention and potential imprisonment. Harper explains her qualifications that should have alerted Thornfield to federal investigation. Harvard Law School constitutional law specialization, 15 years federal civil rights enforcement, and extensive undercover investigation experience across 17 federal districts. My background includes federal constitutional law specialization, civil rights enforcement experience, and judicial oversight investigations pursuant to Department of Justice authority for ensuring constitutional compliance in federal courts. The credentials explain professional competence that should have warned institutional conspirators of federal investigation, while demonstrating comprehensive federal authority for constitutional enforcement. Chief Judge Blackwood confirms Special Agent Sterling's federal authority for investigating constitutional violations, recommending federal prosecution, and pursuing comprehensive civil rights remedies under federal law superseding local judicial immunity. Agent Sterling possesses complete federal authority to investigate systematic constitutional violations, recommend federal criminal prosecution, and pursue institutional reform pursuant to federal civil rights enforcement. The confirmation eliminates any remaining procedural protection for systematic bias, while establishing federal authority for comprehensive enforcement extending beyond individual accountability to institutional transformation. Federal proceedings commence immediately under Chief Judge Blackwood's oversight, combining administrative judicial misconduct authority with criminal referral to United States Attorney for federal prosecution of systematic civil rights violations. I'm convening immediate judicial misconduct of proceedings under 28 U.S.C. Section 372 and referring potential criminal violations to United States Attorney for federal prosecution pursuant to 18 U.S.C. Section 242. The dual proceedings allow simultaneous administrative discipline and criminal prosecution, ensuring comprehensive accountability while preserving due process rights during federal enforcement action. Special Agent Sterling presents federal evidence meeting prosecution standards through audio surveillance, video recording, pattern analysis, and witness statements demonstrating systematic constitutional violations requiring immediate federal intervention. Federal investigation documented pattern and practice civil rights violations through comprehensive surveillance, statistical analysis, and witness testimony meeting federal criminal prosecution standards for conspiracy and civil rights deprivation. The evidence compilation eliminates reasonable doubt regarding systematic constitutional violations while providing foundation for criminal prosecution and comprehensive institutional reform under federal oversight. Federal Observer Martinez confirms administrative office investigations supporting systematic due process violations, equal protection violations, and civil rights deprivation affecting documented minority plaintiffs over 18-month investigation period. Administrative Office investigation confirms systematic constitutional violations affecting 47 documented victims through pattern analysis demonstrating discriminatory treatment violating federal civil rights guarantees. The official confirmation provides institutional support for federal prosecution while documenting comprehensive scope of constitutional violations requiring federal intervention extending beyond individual accountability. United States Attorney Griffin Wade announces federal criminal investigation including potential charges under multiple federal statutes carrying significant imprisonment and mandatory minimum sentences for civil rights violations under color of legal authority. Evidence supports federal charges including 18 U.S.C. Section 242 civil rights deprivation, 18 U.S.C. Section 241 conspiracy against rights, and obstruction of justice under federal law enforcement authority. The criminal charges carry substantial imprisonment up to 10 years and federal conspiracy liability for all participants in systematic constitutional violations, transforming professional misconduct into criminal justice matter. Judge Thornfield's desperate appeal for appellate review demonstrates misunderstanding of federal law enforcement authority operating independently of judicial control when investigating systematic constitutional violations by federal officials. I demand immediate appellate review of these unprecedented proceedings violating judicial independence and due process protections. The appeal has no legal foundation because federal civil rights investigations operate under Department of Justice authority superseding judicial control when constitutional violations create federal enforcement priorities. Defense Attorney Ashford's attempt to challenge federal authority through procedural objections demonstrates desperation rather than legitimate legal strategy, revealing understanding that federal evidence eliminates any defense based on legal merit. Agent Sterling, did federal investigation obtain proper judicial authorization before conducting undercover surveillance of federal court proceedings? The question misunderstands federal law enforcement authority requiring no judicial permission for investigating civil rights violations, including systematic judicial misconduct threatening constitutional protections. Special Agent Sterling explains federal authority operating under Attorney General oversight for investigating constitutional violations by federal officials, eliminating any requirement for judicial approval of law enforcement operations. Federal civil rights investigations operate under Attorney General authority pursuant to Department of Justice responsibility for ensuring constitutional compliance. Judicial consent is not required for federal law enforcement operations. The explanation establishes federal supremacy over judicial control when constitutional violations create federal enforcement priorities, requiring immediate intervention to protect civil rights guaranteed under federal law. Cross-examination reveals Ashford's coordination with systematic bias, while exposing institutional conspiracy that creates federal criminal liability for all participants in coordinated constitutional violations affecting protected classes. Special Agent Sterling's testimony documents coordination between court personnel and defense counsel to frustrate constitutional litigation through procedural manipulation and systematic bias violating federal conspiracy laws. Evidence demonstrates systematic coordination to deny constitutional protections through procedural harassment, evidence manipulation, and intimidation tactics affecting minority plaintiffs seeking federal civil rights protection. The conspiracy evidence meets federal prosecution standards while documenting institutional pattern requiring comprehensive intervention, extending beyond individual accountability to systematic reform. Chief Judge Blackwood announces preliminary findings supporting immediate suspension pending comprehensive federal investigation that protects judicial integrity while ensuring due process during criminal prosecution proceedings. Preliminary findings support immediate suspension from federal judicial duties, pending comprehensive investigation by Judicial Conduct and Disability Committee under federal oversight authority. The suspension represents significant but incomplete federal victory, protecting constitutional compliance while maintaining due process rights during ongoing criminal investigation and administrative proceedings. Federal suspension eliminates Judge Thornfield's authority for continued constitutional violations while preserving evidence for criminal prosecution that could result in imprisonment and permanent federal criminal record. United States Attorney Wade announces formal criminal investigation requiring months of grand jury proceedings, witness testimony, and evidence analysis before final charging decisions affecting all participants in systematic constitutional violations. United States Attorney's Office opens formal federal criminal investigation into systematic civil rights violations. Federal grand jury proceedings will determine appropriate criminal charges pursuant to federal law enforcement authority. The criminal investigation represents serious federal commitment but requires extended proceedings before final accountability, demonstrating realistic timeline for federal justice rather than immediate resolution. Administrative Office initiates comprehensive institutional review examining systematic problems beyond individual misconduct, requiring years for complete implementation while providing immediate federal oversight of constitutional compliance. Administrative Office initiates comprehensive review of federal court civil rights compliance across the district. Federal monitors will oversee judicial conduct pending investigation completion and institutional reform implementation. The institutional review addresses systematic bias affecting multiple judges and administrative procedures, but comprehensive implementation requires sustained federal commitment extending beyond immediate investigation. Court personnel face varying consequences based on participation levels and cooperation with federal prosecution, demonstrating realistic outcome variation rather than uniform accountability for institutional conspiracy participants. Federal investigation includes all participants in civil rights conspiracy. Individual charges will reflect specific criminal conduct, cooperation levels, and prosecutorial discretion pursuant to federal law enforcement priorities. The varied accountability reflects federal prosecutorial discretion while maintaining potential criminal liability for all conspiracy participants, ensuring comprehensive investigation without predetermined outcomes. National media coverage brings public attention to systematic federal judicial misconduct affecting constitutional protections, but institutional change requires sustained pressure extending beyond temporary news coverage. Federal Bureau of Investigation Civil Rights Investigation exposes systematic judicial bias affecting minority plaintiffs seeking constitutional protection in federal courts nationwide. The media attention generates congressional oversight interest and civil rights organization involvement. But lasting institutional change requires continued federal commitment and community advocacy extending beyond immediate publicity. Community vindication provides moral victory and legal foundation for civil lawsuits affecting 47 documented victims. But institutional protection requires ongoing federal oversight and sustained advocacy efforts. Federal investigation validates community concerns about systematic judicial bias while demonstrating need for continued federal oversight ensuring constitutional compliance for all citizens. The community recognition represents important progress while acknowledging that constitutional protection requires sustained federal commitment, extending beyond immediate investigation and individual accountability. Special Agent Sterling receives professional recognition for successful undercover investigation, exposing systematic constitutional violations, while emphasizing federal commitment to civil rights enforcement regardless of official position or institutional authority. Federal Bureau of Investigation Civil Rights Enforcement protects constitutional guarantees for all citizens regardless of race, economic status, or legal representation pursuant to federal law enforcement responsibility. The professional vindication demonstrates individual agent dedication while representing broader federal commitment to constitutional enforcement extending beyond specific investigation to institutional transformation. Federal investigation establishes precedent for comprehensive civil rights enforcement in federal courts. But implementation requires continued federal oversight and community advocacy, ensuring sustained institutional compliance. Federal civil rights prosecution sends clear message that systematic constitutional violations will not be tolerated regardless of official position, institutional authority, or historical immunity from oversight. The precedent provides foundation for future constitutional enforcement while requiring sustained federal commitment to ensure comprehensive implementation across federal court system. Federal investigation continues with preliminary findings supporting criminal charges and institutional reform, but final resolution requires months of additional proceedings demonstrating realistic timeline for comprehensive justice. Preliminary findings support comprehensive federal intervention, but final outcomes depend on continued investigation, federal prosecution, and sustained community advocacy, ensuring constitutional compliance. The ongoing status represents significant progress while acknowledging that complete justice requires sustained federal commitment extending beyond immediate accountability to institutional transformation. Institutional reform implementation begins through federal oversight mechanisms and bias training, but comprehensive cultural change requires years of sustained federal commitment and community pressure ensuring constitutional compliance. Federal court administration implements procedural reforms designed to prevent future constitutional violations, but lasting change requires comprehensive cultural transformation extending beyond immediate administrative adjustments. Systematic issues receive federal acknowledgement requiring congressional action and sustained oversight, but comprehensive solutions depend on political commitment that may not materialize without continued advocacy pressure. Individual accountability represents an important step, but systematic change requires broader federal commitment to civil rights enforcement and sustained congressional oversight ensuring constitutional compliance. The institutional acknowledgement provides foundation for broader reform while requiring sustained political pressure to ensure comprehensive implementation across federal court system. Federal consequences vary among conspiracy participants based on cooperation levels and prosecutorial discretion, demonstrating realistic outcome variation rather than uniform accountability for systematic constitutional violations. Justice remains uneven despite federal intervention, but significant progress toward constitutional compliance creates foundation for continued advocacy and federal oversight ensuring equal protection under law. The federal investigation represents substantial victory for constitutional enforcement while acknowledging broader questions about systematic judicial bias, requiring sustained federal commitment to comprehensive institutional reform. Special Agent Sterling receives classified communication indicating civil rights violations extending beyond current district into systematic judicial bias, affecting federal courts nationwide, requiring expanded federal investigation. Additional evidence suggests systematic civil rights violations extending across multiple federal districts. Federal investigation scope may expand pursuant to pattern analysis, revealing institutional constitutional violations. The expanded scope transforms individual accountability into comprehensive federal civil rights enforcement initiative requiring sustained federal commitment to constitutional compliance nationwide. Congressional Judiciary Committee receives federal briefing on systematic civil rights violations affecting constitutional protections in federal courts, generating potential legislative oversight and institutional reform initiatives. Committee leadership requests comprehensive federal briefing on systematic judicial bias affecting constitutional rights with potential legislative response ensuring federal court accountability. The congressional interest represents potential institutional support for comprehensive reform while requiring sustained political pressure to ensure legislative action extending beyond individual accountability. FBI director authorizes expansion of civil rights investigation based on pattern analysis revealing systematic constitutional violations, requiring comprehensive federal intervention across multiple districts nationwide. Federal Bureau of Investigation Civil Rights Division authorized to expand constitutional enforcement investigation nationwide pursuant to pattern analysis indicating systematic violations requiring comprehensive federal intervention. The authorization transforms Operation Clean Gavel into Nationwide Federal Civil Rights Enforcement Initiative, representing comprehensive federal commitment to constitutional compliance, extending beyond individual district accountability. Special Agent Sterling's investigation concludes with federal authority for continued constitutional enforcement, while opening broader questions about systematic institutional reform requiring sustained federal commitment and community advocacy. The revelation that Harper Sterling represents federal law enforcement conducting authorized civil rights investigation transforms systematic judicial bias from local immunity into federal criminal liability, demonstrating that constitutional protections extend to all citizens regardless of local institutional resistance. Federal investigation provides foundation for continued constitutional enforcement, while requiring sustained commitment to comprehensive institutional reform, ensuring equal protection under law for all citizens seeking federal civil rights protection. The story demonstrates federal law enforcement capability for investigating and prosecuting systematic constitutional violations regardless of official position or institutional authority, while emphasizing that complete justice requires sustained federal commitment extending beyond immediate accountability to comprehensive institutional transformation, ensuring constitutional compliance for all citizens. 6 months later, the transformation of Courtroom 3A represents both significant progress and ongoing challenges in federal constitutional enforcement. Judge Victoria Thornfield sits in federal custody awaiting trial on multiple civil rights violations carrying potential sentences up to 25 years in federal prison. The preliminary proceedings resulted in Thornfield's immediate suspension and federal criminal charges, but her case demonstrates the realistic timeline required for comprehensive federal justice, extending far beyond dramatic courtroom revelations. Court clerk Lila Fairbanks accepted a federal plea agreement requiring cooperation with ongoing investigation in exchange for reduced charges, providing crucial evidence about institutional coordination while receiving probation and permanent federal employment prohibition. Defense attorney Wells Ashford faces federal bar investigation and potential criminal charges, but his case remains pending federal prosecutorial review, demonstrating the complex legal processes required for comprehensive accountability in institutional conspiracy cases. Bailiff Camden Pierce received federal prosecution for civil rights violations under color of law enforcement authority, resulting in conviction and 18-month federal imprisonment, representing the most immediate accountability for institutional conspiracy participation. The varied outcomes reflect federal prosecutorial discretion and cooperation levels while maintaining comprehensive investigation of systematic constitutional violations, affecting dozens of documented victims over multiple years. Special Agent Harper Sterling received federal recognition for exceptional undercover investigation, leading to comprehensive civil rights enforcement, while her identity revelation demonstrated FBI capability for investigating constitutional violations at all levels of federal government. Her 18-month investigation documented systematic bias affecting 47 minority plaintiffs while exposing institutional conspiracy, requiring ongoing federal oversight and comprehensive reform extending beyond individual accountability. Chief Judge Evelyn Blackwood oversees implementation of federal monitoring requirements designed to prevent future constitutional violations, but comprehensive institutional change requires sustained federal commitment extending beyond immediate investigation. The federal oversight includes bias training, procedural reform, and statistical monitoring of case outcomes, providing foundation for continued constitutional compliance while requiring ongoing federal supervision, ensuring equal protection under law. Courtroom 3A now operates under federal monitoring with new judicial assignment designed to restore constitutional compliance, but lasting cultural change requires sustained federal oversight and community advocacy, ensuring equal protection for all citizens. The physical space remains unchanged, but federal supervision transforms institutional culture from systematic bias toward constitutional compliance, demonstrating both progress achieved and ongoing challenges requiring sustained federal commitment. Civil rights advocates monitor ongoing proceedings to ensure federal oversight effectiveness while maintaining pressure for comprehensive institutional reform extending beyond immediate investigation to systematic transformation. Their continued advocacy represents essential community involvement in constitutional enforcement, demonstrating that federal investigation provides foundation but sustained pressure ensures comprehensive implementation of constitutional protections. The 47 documented victims of systematic bias pursue individual civil lawsuits based on federal investigation findings, creating additional accountability while providing monetary compensation for constitutional violations. Civil litigation extends beyond federal criminal prosecution to provide individual remedies while maintaining pressure for institutional accountability, demonstrating comprehensive approach to constitutional enforcement, including both criminal and civil remedies. Federal statistical monitoring reveals gradual improvement in constitutional compliance, but complete institutional transformation requires years of sustained federal oversight ensuring equal protection under law for all federal court users. The monitoring data provides objective measurement of progress while identifying remaining challenges requiring continued federal attention, demonstrating realistic timeline for comprehensive constitutional compliance. The ripple effects of Operation Clean Gavel extend far beyond the federal courthouse walls into the broader legal community across the district. Law schools now incorporate Special Agent Sterling's case study into constitutional law curricula, teaching future attorneys to recognize systematic bias while understanding federal enforcement mechanisms that protect civil rights regardless of local resistance. The Federal Judicial Center develops new training protocols based on Sterling's investigation findings, requiring mandatory bias recognition training for all federal judges, court personnel, and administrative staff. These programs address both conscious and unconscious prejudice while establishing reporting mechanisms for constitutional violations that bypass local authority when systematic bias threatens equal protection under law. Local bar associations implement ethical review procedures for attorneys who demonstrate coordination with judicial bias, recognizing that legal profession integrity depends on constitutional compliance rather than institutional loyalty. Defense attorneys now face professional accountability for systematic coordination designed to deny constitutional protections to minority plaintiffs seeking federal civil rights remedies. Civil rights organizations establish monitoring programs in federal courts nationwide, using Sterling's documentation methods to identify systematic bias patterns before they reach the level of criminal conspiracy. These grassroots monitoring efforts provide early warning systems for federal intervention while maintaining community involvement in constitutional enforcement. The Department of Justice Civil Rights Division expands undercover investigation capabilities based on Operation Clean Gavel's success, training additional federal agents in judicial misconduct investigation techniques while developing systematic approaches to identifying institutional bias patterns across federal court systems. Federal public defender offices receive additional resources for constitutional challenges based on Sterling's investigation revealing systematic bias affecting indigent defendants. Enhanced federal representation ensures that constitutional protections remain accessible to all citizens, regardless of economic status or ability to retain private counsel, demonstrating comprehensive commitment to equal protection under law for all federal court users seeking constitutional remedies. Congressional oversight generates legislative proposals for federal court reform based on Special Agent Sterling's investigation findings. But comprehensive implementation depends on sustained political commitment extending beyond immediate media attention. The legislative interest provides potential institutional support for comprehensive reform while requiring continued advocacy pressure to ensure congressional action resulting in meaningful constitutional protections. 6 additional federal districts face similar FBI investigation based on pattern analysis revealing systematic constitutional violations extending beyond individual courthouse to institutional problems, requiring comprehensive federal intervention nationwide. The expanded investigation demonstrates federal commitment to comprehensive civil rights enforcement while revealing scope of systematic constitutional violations requiring sustained federal attention across multiple jurisdictions. Operation Clean Gavel becomes model for federal constitutional enforcement, providing template for investigating systematic judicial bias affecting civil rights protections guaranteed under federal law to all citizens, regardless of local institutional resistance. The operation's success encourages additional civil rights investigations while providing procedural framework for comprehensive constitutional enforcement extending beyond individual accountability to institutional transformation. Special Agent Sterling's next assignment involves systematic voting rights violations in federal courts across 3 southern states, demonstrating continued federal commitment to constitutional enforcement extending beyond individual investigation to comprehensive civil rights protection. Her continued work represents ongoing federal civil rights enforcement while indicating that constitutional protection requires sustained federal attention extending beyond individual cases to systematic institutional accountability. The story of systematic bias, confronting federal constitutional enforcement, demonstrates that equal protection under law remains an ongoing challenge requiring sustained federal commitment, community advocacy, and individual courage to ensure constitutional protections for all citizens regardless of race, economic status, or local institutional resistance. Federal investigation provides foundation for constitutional compliance, but comprehensive implementation requires sustained effort, extending beyond immediate accountability to institutional transformation, ensuring equal protection under law for all citizens seeking federal civil rights protection. The transformation of Courtroom 3A from systematic bias toward constitutional compliance represents both significant achievement and ongoing responsibility for maintaining equal protection under law through sustained federal oversight, community advocacy, and individual commitment to constitutional principles. Special Agent Harper Sterling's revelation that federal law enforcement monitors constitutional compliance at all levels of government provides reassurance that systematic bias faces federal accountability, while requiring continued vigilance to ensure comprehensive implementation of constitutional protections for all citizens. The case demonstrates that while justice may be delayed, federal constitutional enforcement provides ultimate accountability for systematic violations of equal protection under law, ensuring that constitutional rights remain meaningful protections rather than empty promises for all citizens regardless of local institutional resistance or historical immunity from oversight.